There's nothing more daunting than watching a family member or a loved one be put in handcuffs, hauled off to jail. You getting that phone call from that blocked number, that strange number, and your loved one on the other side of the phone, that father away from his children, that son away from his mother. And your question is always, I just want my son to come home, my daughter to come home while they face these charges. So how do I bail my son or daughter out of jail? Well, bail is a process. There are some constitutional concerns as it relates to bail. There are some statutory concerns, particularly here in Arizona, as it relates to bail. Most offenses are bailable as a matter of right in the state of Arizona. There are some charges that you can be faced with, or charged with, I should say, that are not bailable. At an arraignment or at some other hearing, the judge will normally set release conditions in bail, and it could be a cash bond, it could be a bail amount or whatnot. After you get that amount, you can either post that amount in cash, you can contact the bail's bondsman and work with them. Sometimes they require collateral or different things to where you can get that person out of jail while their charges are still pending against them. One of the things that's important to know about bail, though, is that that person has to show up to court. They have to make sure that they're at all of their hearings, because you don't want to have a failure to appear, because of course that looks, well, it doesn't look good on your record, and the judge is not likely to let you out again if you have a certain number of failure to appears. And again, according to the federal law, that bails and bonds and all of that stuff must be set based on two principles. That they're a danger to the public, is the person a danger to the public, and reasonable enough to ensure that the person is going to return back to court for the hearings that will be after the bail hearing. So you make sure you contact an attorney. There, a lot of attorneys will work with you with the bail's bondsman. We have a list of bail's bondsmen that work with clients and whatnot. But it's something that can be done if a bail has been set in the matter, and if there's been no bail set, there are some opportunities based on under the controlling law to where a defense attorney can request a modification to a bond or a bail amount or release conditions. We can go from whatever the bail amount is to release them to their own recognizance. And this is a decision that the judge will make. The judge will normally hear arguments about it and then go from there. So speak with your family member's attorney, or if you're that person and you have that bail set and you think it's too high and it needs to be lowered. Talk to competent counsel. There are things that can be done to help get you out of jail, or get you to a right bail's bondsman while you're facing these charges. It's a whole lot easier to defend charges when you're out and able to work with your attorney and other witnesses than it will be if you're sitting in jail. So talk to your lawyer, call somebody, and get to work on getting that bail adjusted.